limited issue for the consideration of this constitution bench only relates to the scope of legislative and executive powers of the centre and NCTD with respect to the term services. That is to say, whether the NCTD or the union government has legislative and executive control over services. Then we deal with the constitution bench of 2018 and say, we are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239AA3 balances between the interests of NCTD and the Union of India. Article 239AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase "insofar as such matter is applicable to the Union territories" as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then, page 53. The principles of democracy and federalism are essential features of our Constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in lists 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with a Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is the concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers, who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239 AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive, who are charged with formulating policies in the territory of NCTD, would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Immensely grateful to you, Lord.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. One, whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And two, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench, whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications which require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 को correction है, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve two objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena president, party president, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the legislative party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogawale as the Chief Whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case. And having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the symbols order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the Speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the Speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the Speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, The incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the House to prevent voting for granting leave to move a motion of no confidence. If the speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because 1. The 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Mahavikas Aghadi government, and 2. The MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that a majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Mahavikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no-confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there is a presumption that it enjoys the confidence of the House. There must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio in Maharashtra arose as a result of party differences within the Shiv Sena. However, the floor test cannot be used as a medium to resolve internal party disputes or intra-party disputes. Dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution or through any other methods that the party choose to opt for. There is a marked difference between a party not supporting a government and individuals within a party expressing their discontent with the party leadership and functioning. The governor is the titular head of the state government. It's a constitutional functionary who derives his authority from the constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power that is not conferred on him by the constitution or a law made under it. Neither the constitution nor the laws enacted by parliament provide for a mechanism by which disputes amongst members of a political party, particularly, can be settled. They certainly do not empower the governor to enter the political arena and play a role, however minute, either in inter-party disputes or in intra-party disputes. It follows from this that the governor cannot act upon an inference that he has drawn that a section of the Shiv Sena wished to withdraw their support to the government on the floor of the House. It is true that the letter dated 25 June 2022 sent by some MLAs of the Shiv Sena to the governor requesting him to issue directions to the appropriate authorities for the restoration of their security details mentions that those MLAs no longer wanted to be a part of the corrupt MVA government. However, this cannot be taken to mean that they had withdrawn their support on the floor of the House. Nothing in any of the communications relied upon by the governor indicates that the dissatisfied MLAs from the Shiv Sena intended to withdraw their support to the Chief Minister and the Council of Ministers. At the highest, the various communications expressed the fact that a faction of the MLAs disagreed with some policy decisions of the party. The course of action they wished to adopt in order to air their grievances and redress them was, at the time the floor test was directed to be conducted, uncertain. Whether they would choose to enter into deliberations with their colleagues in the House or in the political party, or mobilize the cadres, or resign from the assembly in protest, or opt to merge with another party was uncertain. Therefore, the governor erred in relying upon the resolution signed by a faction of the SSLP MLAs to conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chowdhury was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with law. Now, on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification. The validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular matter the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker, as communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022, is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where two or more factions claim to be that political party. H. The governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
Grateful to your Lordship.
Immediately. What a correction.
Deeply obliged.
No, obliged to your Lordship.
Deeply obliged.
Thank you for all your assistance. We must thank the members of the bar.
No, yeah, really,
You can never rise
very
above the
patient
thoughts of
hearing.
which we come. Thank you.
Thank you.
government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there is a presumption that it enjoys the confidence of the House. There must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio